Morning and welcome to the second part of our two-part webinar series discussing significant construction and adjudication cases of 2020. These webinars aim to cover key developments in construction and adjudication practice and how these might affect your construction project disputes in 2021. Our webinar today will focus on our chosen top 5 adjudication cases of 2020. We will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. If you would like to ask a question, please do so by using the Ask a Question tab. In order to keep within time, we will be answering as many questions as we can at the end of the presentation rather than as we go along. And if we don't manage to get to your question, or if you are listening to a recording of this webinar, we would be happy to address any queries after the webinar by phone or email. Our contact details are noted on the next slide. I am Nathaniel Buckingham, an associate specialising in construction and engineering dispute resolution. I'm joined by my colleague Ailey Dobson, a solicitor in our team. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. I'll just now pass you over to Ailey, who will run through the agenda for today's webinar.
Thanks, Nathaniel. We'll start by looking at the case of Bresco Electrical Services Limited against Michael J. Lonsdale Electrical Limited, which relates to whether an insolvent entity can refer a dispute to adjudication. We'll then move on to discuss Global Switch Estates Limited against Sadlers, which considered whether an adjudicator's failure to consider a defensive set-off was a breach of natural justice. After that, we'll go on to Lane End Developments Construction Limited and Keystone Civil Engineering Limited, which involve procedural issues relating to the appointment of an adjudicator. Our penultimate case is Q Holdings Limited and Donald Insole Associates, in which the losing party in a smash and grab adjudication tried to progress court proceedings to challenge the valuation of the underlying works before making payment of the smash and grab adjudication decision. Finally, we'll discuss the case of Transform Schools and Balfour Beatty Construction regarding an adjudicator's treatment of documentation marked without prejudice in an adjudication. We would note that regardless of some of these decisions being in Scottish courts and English courts, they would likely be considered highly persuasive in each jurisdiction. Moving on to our first case then, this is Bresco Electrical Services Limited and Michael J. Lonsdale Electrical Limited. So this is decided by the Supreme Court in June 2020. The case is significant because it clarifies the interplay between adjudication and the process of insolvency set-off. As a reminder, when a company enters insolvency, sums due between it and any entity with which it had dealings are set off against each other. And this process is insolvency set-off, and the intention of it is to simplify cross-claims and to ensure that the creditor is not unfairly disadvantaged. The background to the case then was that Lonsdale had engaged Bresco to carry out electrical installation works in St James's Square in London. After carrying out the works, Bresco went into creditors' voluntary liquidation. Each party considered that the other one was in breach of contract, and various contractual claims were intimated between them. In 2018, Bresco's liquidators referred one of the disputes to adjudication, seeking £219,000 in respect of Lonsdale's alleged wrongful termination of contract. Lonsdale, meanwhile, had a £300,000 cross-claim in respect of Bresco's alleged breach of contract, and Lonsdale objected to the adjudication taking place, given Bresco's insolvency. Lonsdale's first argument, the jurisdiction argument, was that the process of insolvency set-off meant that there was no longer a dispute under a construction contract. The former cross-claims had been replaced by a single claim for the net balance, so the statutory regime for adjudication in construction contracts no longer applied. Lonsdale's second argument, the futility argument, was that an adjudication in context of insolvency set-off will not generally lead to an enforceable award, and that as a result it would be an exercise in futility to run an adjudication, and the court can and ordinarily should restrain that by injunction. Neither argument succeeded. On the jurisdiction argument, the court held that when insolvency set-up operates, claims and cross-claims do not lose their separate identity for all purposes. There was still a dispute under a construction contract, and that could be referred to adjudication. On the futility argument, the court held that even if enforcement and adjudication award might not be possible, adjudication still had a purpose, and the court should not interfere with the statutory right to adjudicate. So, what then are the key points to take away from this decision? Firstly, adjudication generally offers a cost-effective and efficient method of dispute resolution. The costs of litigation or of arbitration may seem unpalatable and disproportionate to a liquidator tasked with concluding a final account, but adjudication, on the other hand, may seem more practicable. Secondly, the Supreme Court decision is likely to increase the probability of a construction dispute being referred to adjudication in circumstances where the party has become insolvent. It's worth keeping this in mind if you find yourself in a dispute with a company which seems to be in financial difficulties.
Thank you, Hayley. The second case for us to look at is Global Switch Estates 1 Limited against Sadlers Limited, which considered whether an adjudicator's failure to consider a defence of set-off was a breach of natural justice. As many of you will know, it is settled in adjudication that, firstly, only the dispute referred to in the notice of adjudication may be decided by the adjudicator, and secondly, that a respondent may advance any defence open to it, which may include set-off. In this case, the Technology and Construction Court, the TCC, clarified how these two principles interact in the context of the valuation of an interim application. So the background was that Sadlers Limited was engaged by Global Switch Estates 1 Limited, GSEL, to undertake works in connection with the fit-out of GSEL's specialist data centre, housed in the former Financial Times Print Works building at East India Dock House in London. Now, Global Switch commenced an adjudication, which was the fourth between the parties, seeking valuation of an interim certificate. The claim related to part of the certificate only. In its response, Sadlers argued that it could set off its own claims for increased sums dealt with elsewhere in the certificate. In particular, it sought to set off a loss and expense claim which was in its application, but not part of the referred claim. In his decision, the adjudicator determined that he could not consider the additional loss and expense claim and awarded Global Switch around £5 million. Sadlers did not pay, and Global Switch issued enforcement proceedings in the TCC. As is widely appreciated, the bar for resisting enforcement of an adjudication decision is very high, even if the decision is incorrect in fact or in law. It must be paid unless the adjudicator did not have jurisdiction to reach the decision or breach the rules of natural justice, and the latter includes what in Scotland is termed a failure to exhaust jurisdiction. After considering the full relevant case law, the TCC held that the adjudicator had been misled by GSEL and wrongly failed to consider and deal with matters relied on by Sadlers as defences to GSEL's claim, thereby acting in breach of the rules of natural justice. Now, GSEL was not simply claiming for the true valuation of specific parts of the interim application, but also payment of the net sum due as a result of those parts. So the court decided that the adjudicator was entitled to limit the declaratory relief to the issues of valuation identified by GSEL, but determination of the claim for payment, the net payment, however, required the adjudicator to consider all of the matters raised by Sadlers in support of its case that it was entitled to additional sums in relation to other issues of valuation arising out of the same interim application. The adjudicator's failure to take into account Sadler's defence based on its claims for loss and expense amounted, in the court's words, to a plain and obvious breach of the rules of natural justice. The breach was material, and GSEL's case to enforce the adjudication decision was dismissed. This judgment is important since it makes clear that where a referring party seeks payment based on the valuation of a payment assessment, it cannot limit the scope of the dispute to specific items within that assessment. Although this case was concerned with an interim application, the principles are equally applicable to final account disputes. This judgment could be something of a warning to adjudication practitioners that trying to be too clever in order to shut off avenues of defence to the other side, as these can indeed backfire.
Moving on now to the case of Lane End Developments Construction Limited and Keystone Civil Engineering Limited. In this judgment, Judge Hallowell ruled on a number of adjudication procedural issues, including whether the adjudicator had been validly appointed. The judge concluded that the appointment of the adjudicator in this matter was defective, based on the appointment application being premature, and as a result, the adjudicator hadn't had jurisdiction. The background to this case was that Lane End was the main contractor on a housing development at a site in Cheshire. Keystone was appointed to carry out enabling works for the development under a subcontract. The scheme for construction contracts, the England and Wales regulations, applied. On the 20th of March, Keystone submitted a request to the RICS Dispute Resolution Service for the appointment of an adjudicator. Later that day, Keystone gave the Lane End a notice of adjudication, seeking payment of around £350,000. An adjudicator was duly nominated to act by the RICS and accepted the nomination. Lane End challenged the adjudicator's nomination on the grounds that Keystone had failed to give Lane End notice of adjudication under the scheme. The adjudicator disagreed and advised the parties that the notice of adjudication contained a clear intention to refer the dispute described therein to adjudication. The adjudication went ahead, and in his decision, the adjudicator concluded that Keystone was entitled to the full amount sought in the adjudication. But the case was then brought to the Technology and Construction Court, the TCC. The main issues for the court to decide were whether the adjudicator had jurisdiction to make his decision, and if not, whether, as responding party, Lane End had waived that defect by election or was prevented from relying upon the defect. Finding in Lane End's favour and dismissing Kingstone's claim, Judge Hallowell held that the adjudicator's appointment was void. He held that Kingstone's request for the appointment of an adjudicator was not compliant with the scheme on the basis that it was submitted prior to giving the necessary notice of adjudication to Lane End. As such, the adjudicator was not validly appointed and did not have jurisdiction to deal with the dispute. Citing paragraphs 1.1 and 2.1 of the scheme, Judge Hallowell stated that a party to a construction contract is afforded the right to serve notice of adjudication and request the appointment of an adjudicator. There's an obvious logic in providing for the referring party to serve as notice of adjudication prior to the request for the appointment. Notably, paragraph 2.1 of the scheme provides for the referring party to submit its request for the appointment of an adjudicator following the giving of a notice of adjudication. This case is of interest since it serves as a reminder of the importance of strict compliance with procedural rules surrounding adjudication. It's vital that simple procedural errors should not undermine an otherwise valid claim, and parties must pay close attention to the relevant contract provisions, or where relevant, the scheme for construction contracts, and ensure compliance with these to avoid additional cost and time further down the line.
Our fourth case is that of Q Holdings Limited against Donald Insole Associates Limited, where the TCC refused to strike out a claim where a smash and grab decision was not paid. The pay now, argue later regime within the Housing Grants, Construction and Regeneration Act 1996 applied. The background to the case was that Q Holdings engaged Donald Insole Associates to provide architectural services in relation to the conversion of the King's Observatory in Richmond from offices into private residences. In 2018, Donald Insole successfully referred a dispute to adjudication. The adjudication was a smash and grab claim, that is, a claim that payment was due in full as a result of Q's failure to adhere to the strict requirements of the contractual payment mechanism. The valuation of the underlying works was not relevant. Q failed to make a payment, so Donald Insole brought court proceedings to enforce the adjudication decision and obtain summary judgment. When Q failed still to make payment, Donald Insole took steps to enforce the summary judgment that they'd obtained. On the 6th of March 2020, Q raised the present case, a professional negligence claim against Donald Insole in respect of allegedly late and inadequate drawings, inadequate advice, and for overcharging. The effect of success would be to revalue the works for which payment was awarded in the adjudication. Now, previous case law has made it clear that an employer must make payment of an enforceable adjudication award prior to bringing a second adjudication to challenge the valuation of the underlying works. Donald Insole argued that a similar approach should be applied to Q's court proceedings. Q's claim, they said, was an abusive process and ought to be struck out. Donald Insole made various arguments to support this, including that Q had shown a deliberate, persistent refusal to comply with the summary judgment. Now, it was accepted by Q that payments must be made, but Q argued that its court proceedings to revalue the works should be paused rather than struck out pending payment. The TCC refused the application from Donald Insole to strike out the claim and instead paused the proceedings for payment to be made by Q. Amongst the court findings were that the legislative regime for payment in construction contracts specifically enables the employer to bring a challenge after payment. To strike out the claim that Q had brought would be contrary to that regime, since it would deprive Q of the ability to argue later. Q's decision to raise the proceedings, having chosen not to make payment, though, the court said, was in flagrant disregard to the pay now, argue later regime and amounted to unreasonable and oppressive behaviour. The court also noted that Q seemed to have the resources to pay and had simply chosen not to do so. And finally, the previous points notwithstanding, the court decided that striking out would be too draconian. Donald Insole was sufficiently protected by pausing the proceedings until payment, unless and until payment was made. After that, Q would be allowed to pursue its court proceedings. So the TCC's decision here makes clear that an enforceable award in a smash and grab adjudication must be paid before the value of the underlying works can be challenged, whether by adjudication or court proceedings. Although the TCC did not go so far as to strike out Q's claim, the court made clear that Q's failure to pay the adjudication award was unreasonable and justified Q's proceedings being paused. Q would be likely to be exposed to additional costs as a result of that approach. Striking out is a feature of English and Welsh court procedure and typically prevents a claim from being taken any further. The Scottish courts do not have a direct equivalent, but can dispose of proceedings by various mechanisms throughout the course of a court action. It is likely that courts in Scotland would follow a similar approach to the TCC's approach in this case.
Thanks, Nathaniel. Our final case is that of Transformed Schools against Balfour Beatty Construction. This judgment was given in February 2020. The background to this case was that in 2005, Transformed Schools entered into a project agreement with North Lanarkshire Council to design, construct and fit out several schools in North Lanarkshire, including the STEPS project. The STEPS project was constructed between 2006 and 2007. In August 2015, it became apparent that there were various defects in the drainage system, including a collapsed pipe, displaced joints, and a reformed sewer. Further investigations highlighted additional defects, culminating in a drain collapse in June 2019, resulting in emergency repairs. Transformed Schools issued a notice of adjudication to Balfour Beatty in July 2019, and the adjudicator decided in September 2019 that Balfour Beatty should pay Transformed Schools over £4 million in damages. Balfour Beatty did not make payment, and Transformed Schools raised commercial action in the Court of Session to enforce the adjudicator's decision. In his decision, the adjudicator had referred to 3 documents presented by the parties that were marked as being without prejudice. They were either titled as such, or they made reference within them to remedial works being carried out by the defenders on a without prejudice basis. The adjudicator, who was an English barrister, had considered the admissibility of the documents, and he decided that regardless of the without prejudice tag, the content of the documents was admissible. Balfour Beatty maintained that the without prejudice correspondence was protected against any use in the adjudication process, and that the adjudicator had wrongly relied upon the correspondence to a material extent in determining issues critical to liability. They argued that the use of this correspondence offended the public policy principle that undermines without prejudice privilege, and that the adjudicator's error amounted to a material breach of natural justice, such that the decision was unenforceable. Transformed Schools disagreed and highlighted that both parties had been afforded the opportunity to make representations on the admissibility of the correspondence in adjudication, as such that there could not be any breach of natural justice. Further, they maintained that these considerations were not material to the adjudicator's decision and so were insufficient to undermine the decision. In its judgment, the Court of Session made clear that the admissibility of the without prejudice letters was not being decided. The Court found that the adjudicator was entitled to consider the question of whether or not the letters were admissible. The adjudicator may or may not have been right to decide they were admissible, but even if he was wrong, then that was an error of law, and an error of law on the part of the adjudicator does not by itself render a decision unenforceable. This case makes our top 5 as it highlights again the limited scope that exists to challenge the enforceability of an adjudication decision. It also provides a reminder that the words without prejudice cannot be tagged onto any documentation to prevent that documentation being relied upon in court proceedings. It's the content of the documentation which will always decide whether or not it's protected.
So that's us gone through our 5 cases today. So I'm just going to summarise with the lessons that we can take away from those cases. Firstly, to be aware of recent developments in relation to insolvent entities referring disputes to adjudication. It may be more likely now than it was previously for an insolvent party to commence an adjudication. Secondly, it is clear that a failure by an adjudicator to consider a relevant defence can amount to a breach of natural justice and may render an adjudication decision unenforceable. Thirdly, procedural rules surrounding the commencement and progress of adjudications can be crucial to jurisdiction and therefore the enforceability of an adjudication decision. They should therefore be stringently applied by all parties. Fourthly, where an adjudication decision is enforceable, payment of any sum awarded must be made before the dispute can be referred to court for final determination. And finally, an adjudicator making an error in law is not itself sufficient to render a decision unenforceable. In addition, parties should exercise caution when using without prejudice on the correspondence, as the application of this privilege will depend on the contents of correspondence, not on the use of the phrase itself.
That brings us to the end of the main part of the webinar. We've had one question in just relating to the Bresco case, which is why wouldn't the adjudication decision in favour of the insolvent party be enforceable? I think it stems mainly from the adjudication decisions only being binding on an interim basis. The idea behind that is that the paying party shouldn't have to pay to an insolvent party, given that the insolvent party then is very unlikely to have funds available if ultimately the decision is challenged in court and the funds have to be repaid. It's important to note, though, it isn't actually a certain position, and there were a couple of cases, actually also in 2020, on this point. The first one, I think, was John Doyle Construction against Urith Construction. The court in that one set out a number of principles that should be considered when deciding whether or not a decision in these circumstances will be enforceable. And one that's really important was whether or not the liquidator was able to put forward security to essentially ring fence the funds that were coming in from the adjudication decision. And if they were able to provide that security, then it may be that this decision would be enforceable, notwithstanding the insolvency. That's then exactly what happened in a follow-up case later on with Stiles and Wood against GECIF Limited, Trustees Limited. In that one, the liquidator was able to obtain an after the event insurance policy, and that acted as sufficient security, and the adjudication decision therefore was enforceable. So what you can see from those is that it is an unclear position, and it's always worth considering very carefully what the actual facts are of the matter when you're looking at any sort of adjudication involving an insolvent party. I think that's us come to the end of today's webinar. So we hope that's been an informative look at some of the most important adjudication decisions in 2020. Certainly, if there are any further questions, please do submit them to us and we'll get back to you as soon as we can. An on-demand version of the webinar will shortly be sent to you all should you wish to share it or watch it again at your convenience. And we thank you all for listening and hope very much that you'll join us again at some of our future webinars in 2021.